Your Money and Your Life podcasts by Mogers Drewett to help you navigate life's legal and financial challenges.
This short podcast series features 2 special episodes aimed at parents with SEN children and raises important questions relating to the long-term support for vulnerable children. We offer guidance surrounding the processes that parents might need to consider as their child approaches 18. Processes that will allow them to continue making important welfare and financial decisions on their behalf into the future. My name is Anne-Marie Worth. I'm a solicitor at Mogers Drewett, specialising in wills, probate, later life and court protection work. Nicola Setchell is an administrator at Mogers Drewett. She has a 14-year-old son with special educational needs. So the questions Nicola raises today are very much from a personal perspective, but she hopes that the issues discussed will resonate with other parents of SEN children.
Hi, Anne-Marie.
Hi.
How you doing? All right?
Thank you.
Good. Thanks very much for talking to me today. Now, if I just start by telling you a little bit about my circumstance. So, as you mentioned in the introduction, I have a 14-year-old son with learning disability. Now that he's 14, we're at the point where we need to start thinking about his care moving into adulthood. And I know part of that is going to be us having to consider how we manage his financial affairs going forward. So I wanted to ask you today a little bit about what I can do to put processes in place really to assist with that. I understand a little bit that I probably have the options of either a lasting power of attorney or a deputyship. And I'm wondering if you could just maybe start by telling me a little bit about what each of those are.
Of course, yes. So the 2 processes are quite different, but they both give authority to another person to make legal decisions on behalf of someone else. So a lasting power of attorney, known often as LPA, is a legal document which someone makes appointing a family member, trusted family member or friend or a professional to act on their behalf at some point in the future if they became mentally incapable of making those decisions for themselves. A deputyship is applied for in a situation where a person already has lost mental capacity and decisions are needed at that point. It's probable that it's too late for them to make a lasting power of attorney because they lack capacity to do so. So the third party, such as a parent, family member, friend, or other appropriate person, professional even, will make an application to the Court of Protection to obtain an order which will authorise them to make decisions on behalf of that person. So it's sort of the timing that is really the difference and mental capacity. It may often be the case that with a SEN child, they may not have the mental capacity to make an LPA because of their situation, in which case a deputyship application would be the sort of correct route. But we shouldn't presume that all people under that certain category do not have the capacity to make an LPA, and often they will have the requisite understanding, and with the right support and tools, they will be able to make a lasting power of attorney, which would be probably the preferred option in most cases.
Absolutely. So if a child's maybe got that understanding, then we can look at the LPA route. If you really think that they're not going to be able to understand what's being asked of them, we're going down the deputyship route.
Really, in a nutshell, yeah.
Brilliant. So what are the features of each?
Okay, so the features are again different as between them both. So a lasting power of attorney, again, as I said before, it's a document that that the person makes. They are appointing their chosen attorneys. You can choose as many as you like, but it's normally up to four people in practical terms. That's the most appropriate. So if a SEN child is making an LPA, typically it may be a parent or both parents, but you can also have more than 2. So a sibling may be an appropriate choice as well if they're of an appropriate sort of age and ability to carry out that role. And ordinarily you would appoint them jointly and severally, not in all cases, but jointly and severally, which means that the attorneys can act independently and also together for significant decisions. You can also appoint replacement attorneys. So if the original attorneys die or they lose mental capacity themselves or can't act for any other reason, you've got backups there. So you can make it quite bespoke in that regard. You can place restrictions and conditions in your LPA to suit your needs. And the LPA is then registered and is a valid document to be used at some point in the future. There's two types. There is a financial LPA, which covers all financial related decisions, including investing money, looking after bank accounts, dealing with welfare benefits, income, paying bills, mortgages, that sort of thing. And the health and welfare LPA, which covers all other decisions. These decisions can include where you live, who you spend time with, consent to medical treatment, and things like your care decisions. So a deputyship, as I've said before, is an application made on a mentally incapacitated person's behalf by a third party. The court will give the order. They make the order appointing the chosen deputy who is applying for the order. So there's it's quite a long sort of involved process, and the deputy, the applying, will need to submit quite a lot of evidence in their application to prove to the court that a deputyship application is needed and they are an appropriate candidate to carry out that role. And that takes quite a long time to get. And also, once a deputyship order is made, you are accountable to the court on an ongoing basis, basically forever, until such point as the deputyship order is no longer in existence. Mm-hmm. So there is an ongoing accountability, and the deputy needs to deliver up yearly accounts to the court to account for the decisions they've made on a year-to-year basis.
Are there anything that you can't do with an LPA or a deputyship?
So there are certain restrictions. So with an LPA, the LPA does normally give an overall authority over someone's affairs, but this is subject to any restrictions or conditions that are placed in the LPA, which they would need to adhere to. Mm-hmm. With a financial LPA can actually be used whilst a person still has mental capacity, subject to their consent. So the person would need to consent to any decisions made on their behalf whilst they have capacity to do so. But in relation to a SEN child in particular, an LPA in this situation might be a really good thing to have. Even if they have some capacity to make decisions, they're probably going to need some support, aren't they, now and into the future. So that flexibility is actually really good, that their parents can step in whilst they have a capacity, and if things change in the future and their capacity fails. There is a restriction about gifting. An attorney can't gift money on behalf of someone from their money to a third party. So if you want to do that, you have to make an application to the Court of Protection. With a deputyship order, the restrictions are covered by the actual order. So what you can and can't do is covered by the terms of the order. In relation to both a LPA and a deputyship, you can't make a will on someone's behalf, okay? You have to make, again, a separate application to the Court of Protection. The other sort of quite significant thing to mention in this regard is that a deputy or attorney is subject to the Mental Capacity Act 2005. So any decisions they make on behalf of someone must be made in accordance with their best interests. And that is at the heart of the Mental Capacity Act. And there are lots of things and criteria that they would need to consider in any best interest decision. So it's not just a free-for-all to make decisions, at their whim. They do have guidelines and rules that they would need to follow.
Yeah, great. So what age should you begin applying for either an LPA or a deputyship?
Okay, well, this is particularly a good question in relation to a SEN child, because before they reach 18, their parents will have automatic parental responsibility for them, so they can make decisions on their behalf as of right whilst the child is a minor. However, as they are approaching adulthood, that automatic right will stop. Once they reach 18, that will stop. So they would need to consider, I guess, as the child is approaching that age, whether they would need to put something in place to be able to continue managing their affairs and making decisions on their behalf if they still need that support into adulthood. So If that's an LPA, because the child has mental capacity to make one, it will be 18 that the child can legally make an LPA. With a deputyship, again, it would be 18 that they would have to consider putting a deputyship application in place. But certainly, whilst the child is a teenager and approaching adulthood, is a really good time to start thinking about all these things.
What would happen if either an attorney or a deputy that you've appointed passes away? What would you do then?
Okay, so it would be hoped that those sorts of issues would be covered when you originally set up the authority. And obviously, if we're advising clients in relation to setting up an LPA or applying for a deputyship, we would hopefully cover the event of a deputy or an attorney dying. So perhaps you can appoint 2 or more attorneys, so that if one of the attorneys or deputies dies, you then have the surviving one that could act. So jointly and severally is obviously the significant appointment in this situation. With an LPA, if you have 2 attorneys or more, for example, you can appoint replacement attorneys that would step in if one or both of the original attorneys couldn't act. And with a deputyship, you can't appoint replacement attorneys, but you can have joint and several. And hopefully then the remaining deputies can step in that situation. If it's not covered initially, then it makes matters a little bit more complicated. Because if then an LPA is invalid because you don't have an attorney to act, or with a deputy dies or both deputies die and you don't have any remaining deputies, you will go and you would have to start the processes again with an LPA, make a completely new LPA, appointing new attorneys, and with a deputyship, make another application to the court. So it's good to get it right at the beginning, isn't it? But sometimes the things are out of your control. I appreciate.
Yeah, absolutely. So it sounds like you've really got to, when you're sort of starting this process, not just think about sort of your immediate goals, but also think longer term, what happens after perhaps you as parents die and who would take up that reign. And that's probably a good thing to think about now at the beginning rather than, at the process when one or other passes away.
So I think so, given the complicated nature of these things and the length of time, I think cover all these things right at the beginning and we can take you through everything that you need to think about and advise you appropriately.
Yeah. And can they be changed at any point as well?
So an LPA unfortunately can't be changed once it's registered. So the process is that the LPA is prepared, signed by all parties and sent off to the Office of the Public Guardian for registration, which takes a few months. Once it's registered, that document can't be changed. So if a person wants to then make any changes, so that may be they are now not happy with their chosen attorney and wants to remove one, that sort of thing. Unfortunately, they would have to then revoke their existing LPA and start the whole process again and make a new one. Obviously, you still have to have mental capacity in order to revoke your LPA and make a new one, so bear that in mind. With a deputyship application, again, any changes to the order once it's made will require a new application to the court, and that will be subject to the court process, which takes a while, I'm afraid. Any application at the Court of Protection does take quite a long time. Okay, so again, hopefully we can cover as many things as possible when initially making those documents, but they can be changed, but it's not simple.
And in terms of actually going about making either an LPA or a deputyship, what's the procedure? What sort of cost are we talking about and length of time?
Of course, yes. So a lasting power of attorney is a simpler process and quicker process. So I'll start with that first. We would meet with a potential client. We're happy to have that initial conversation over the phone and guide them through everything they need to know before they commit to anything. And then if they want to proceed, we would meet with them and take full instructions and give them, the fullest information we can at that meeting. We're happy to meet people remotely if it's inconvenient for them to come in, although we think it's best to meet clients face to face for obvious reasons. We're happy to be flexible and meet via, video call if that's more convenient. When we get all the initial admin signed dealt with and terms of conditions signed up and everything, we would draft the documentation for the client's approval. and then once that's all approved, make arrangements for the client to sign the document, and then the other parties would sign the document. A certificate provider is a person that is involved in the LPA. The certificate provider's role is to ensure that the person making the LPA has mental capacity when they make it. So I am happy to, as a solicitor, happy to act as certificate provider or an appropriate professional with the relevant skills, but it also can be someone you've known for at least 2 years who's prepared to give that certification. Then all the attorneys need to sign the document before it's then submitted to the Office of the Public Guardian for registration. And as I said, the whole process takes about 3 to 4 months. This will be subject to any delays in the process, any questions the OPG raise, any delays with the attorneys signing and returning the documents. With a deputyship, it's a little bit more involved. There's a bit more to it, and the process is longer. You're looking at about 12 months actually at the moment to get a deputyship in place. You mentioned there actually there is a new online deputyship process which has been introduced this year, which should make the process a little bit more streamlined, efficient and quicker. But if we're just thinking about the traditional route, that is quite a long process. Could be longer than 12 months even. It all depends on the complexity of the case. Mm-hmm. Just briefly, the process again will involve the same sort of initial steps as with an LPA, but then there's more forms to fill out. You have to complete some court of protection forms, which includes all the financial details of the person who lacks capacity, details of their care arrangements, future needs, their family circumstances, and then a medical assessment report needs to be completed by their GP or another appropriate medical professional who confirms that they do actually have, they do lack capacity in relation to the issue in question that you're, in relation to the deputyship. That's all then submitted to the Court of Protection once complete and signed, and then there is sort of quite a long period of review by the Court of Protection. They place the application into the system. There is then a notification process where at least 3 close members of the person who lacks capacity's family or friends need to be notified, and they have an opportunity to object if they disagree with the application or any part of the application, and they can put forward submissions to the court. So there is that process, and the court will then deal with any responses by those people. This could obviously lengthen the process if a deputyship application is contested, and they may the court may require a hearing to take place. They will then raise any queries themselves, deal with any outstanding information, and then 12 months later or so, we'll make the final order. Mm-hmm. Lovely. Okay. In terms of costs, obviously that our sort of precise costs will be subject to meeting you and taking your exact, instructions and establishing your requirements. But generally speaking, our fixed fee for preparing one LPA, so one type of LPA is 500 plus VAT, and for the 2 types of LPAs is 650 plus VAT. Then the Office of the Public Guardian charge £82 to register each LPA. Deputyship costs are a little bit higher, and there's more of those costs, I'm afraid. So you're looking at an initial application fee of £371. That's just to make the application. There is a fee remission or exemption available if the person who lacks capacity's income is below a certain threshold or they're in receipt of certain benefits. Okay, so it's really important that you kind of consider whether that fee can be waived or reduced. Then you've got an initial admin fee of £100. There is the medical assessment fee, which will be that of the GP who prepares the mental capacity report. There is a yearly supervision fee, which will be £320. That's payable every year. Or there is a reduced fee of £35 if the the estate, the person's sort of finances are very simple and below a certain capital threshold.
So, I mean, it sounds like it could be quite an expensive thing to go down. If there are parents listening to this who perhaps are concerned about the costs, or perhaps they have slightly lower incomes, is there any advice you could give them?
Yeah, so I think with the SEN child, a finance deputyship is not always going to be necessary, because they may have limited finances and not much money, and their only source of income may be their DWP benefits, in which case it may be sufficient for a parent or family member to apply to become their appointee. So you apply to the DWP to become their appointee. That's appropriate if all their income is DWP benefits and they have a capital of £6,000 or below. Then they can manage the benefits and pay outgoings from those benefits without the need for a deputyship. However, if the SEN child has income from other sources, such as a trust fund, or they have capital over 6,000, then I'm afraid it is the deputyship route that they would need to follow. There is only those two options, I'm afraid. Yeah.
Thanks, Anne-Marie. That's really, really helpful. And if people want to find out a little bit more from you, how do they go about contacting you?
Okay, yes. So at Mogers Drewett, we have experts who can assist and advise in relation to all of these issues. You can contact us with the details at the end of this podcast, and also go onto our website at www.mogersdrewett.com for more details on how to contact us.
That's great. Thanks very much.
Thank you.
Your Money and Your Life podcast was brought to you courtesy of Mogers Drewett, solicitors and financial planners. On your side, at your side. Call 0800 533 5349 or visit mogersdrewett.com.